Good morning, everybody. Thank you for joining us. Welcome to the Leave of Absence Laws, sponsored by Workforce Development Board of Riverside County. My name is Stephanie. I'm the Marketing Director here at California Employers Association. Before we get into today's training, I just have a couple of details to go over with you. As you can see, your audio will be muted throughout today's presentation. There will be lots of opportunities to engage during the training. If you have any questions about the content, please enter them into the Q&A box at the bottom of your screen and we'll try to address them as we go. If you have any questions about technical issues or needing to receive the handouts, please let me know in the chat box. I will also be putting the handouts in the chat box shortly and you will be able to download them from there. The webinar is being recorded and the team from Riverside County will reach out when it's available for playback. We will also be inviting you to share your feedback at the end of today's training by participating in a brief survey. It's only 5 questions. It'll take you less than 90 seconds to complete. I promise it is very short. The feedback you give us helps us make sure we are meeting and hopefully exceeding your expectations, and it gives us an idea of future trainings you would like to see. Again, our training today is brought to you by Riverside County. Today we are joined by Jason Tang, the Development Manager, and he is going to share a little bit more about the resources available to employers like you.
Thank you so much, Stephanie, and welcome to everybody for taking to this webinar and for taking the time to be with us. As you can see on your screen right now, one of the many resources that we have is a free HR hotline that is for you to use. So if you have any questions on any of the guidance there that you see, or any other questions that have to do with HR, I highly encourage you to use this hotline. They have experts on hand who are ready and willing to answer any questions that you might have. And so it's a wonderful resource. It's one of many programs, services, and resources that we offer at no cost to you, the employers here in Riverside County. We are here to serve you, or you're here to help you. I highly encourage you to take that survey that Stephanie talked about. We perform about 6 of these webinars every year or more, and we take a lot of the feedback that you give to us on what topics would be most helpful for you. So we are here to serve you, and thank you so much for taking the time to be with us today. Stephanie, we'll send it back to you. Thanks.
Thank you so much, Jason. All right, now I'd like to introduce our trainers. We've got 2 wonderful people here today. We have Juliana Gabriel, our Senior HR Compliance Director, and Astrid Servin, one of our Human Resource Directors, leading today's session. So you are in great hands. With that, I'm going to pass it over to you, Juliana and Astrid.
Thank you, Stephanie, and thank you, Jason. We really appreciate your partnership. For those of you who are just joining us for the first time, I'd like to introduce California Employers Association, or CEA. We are an HR consulting company. We have members located throughout the state of California and beyond, and our focus is providing you peace of mind with exceptional HR compliance solutions. So just to give you a little bit of an idea of what it's like to be a CEA member, if you find you need some additional HR support beyond that hotline, all of our members get access to our hundreds of sample forms, policies, and toolkits, which we're constantly keeping up to date with all of California's changing requirements. So that can be really useful to use those forms in your day-to-day HR practice. And we can also help you out with projects. So if you need a customized employee handbook, assistance with an internal workplace investigation, training for your staff like harassment prevention training, coaching, we can help out with all of those types of services. So we have our website listed here, employers.org. We also have our main line. You're welcome to call us directly at any time with any questions you have about membership or our services. Now, I do want to note that this presentation today is for educational purposes only and should not be relied upon as legal advice. So just a reminder, CEA is not a law firm. We cannot give you legal advice when you're calling into that hotline or on these trainings. We are giving you general guidance and best practices. But as Stephanie mentioned, you're more than welcome to ask us questions about the content today. While I'm presenting on the first half, Astrid's going to be in that Q&A box answering your questions, and then we'll switch halfway through. We want to make it as useful and practical for you as possible, so please do not hesitate to ask your questions. All right, so let's talk about what is on our agenda today. Leaves of absence is such an important topic in California. Just because we have so many different leave laws compared to other states, we have around 30 different leave laws that could apply, and they're all pretty nuanced in terms of leave eligibility requirements, who are covered employers. So we're going to unpack that for you today and give you a really strong foundation when it comes to California leave of absence. As we're going to learn, a lot of leaves of absence are based on employee headcount. And so the larger the employer that you are, the more employees you have on your payroll, the more leave laws that are going to apply to you. The leave laws also come with different employee rights. So for example, we're going to go over this, but the California Family Rights Act leave and FMLA, they come with continuation of healthcare coverage, the right to reinstatement after someone returns from the leave. So it's really important to understand what are those additional protections that those certain leaves carry. Another key point is how to properly designate and document those leaves. What kind of paperwork do you need for each one? And then we're also going to cover how those leaves impact use of PTO, vacation, and sick leave. A lot of leaves are unpaid by default, but oftentimes employees can use their accrued time to turn it into a paid or partially paid leave. So we will go over that as well. All right, so let's jump right into managing leaves of absence in California and start with our ground rules. So really important that you have clear handbook policies. There are some policies that are mandatory like CFRA and FMLA. Other policies, leave policies are optional, but we would recommend that you have a policy for each leave law that applies to your business. The reason being, again, as I mentioned, there's a lot of information, they're pretty nuanced, and so it's nice to have a reference point where you can go and determine which leave laws might be at issue. And it also ensures that your supervisors or your management team are providing consistent information to your employees. Another really key point is that you actually designate the leave, that you're documenting it in the personnel file. We have a lot of employers that will call us and they'll say, yeah, I have this person out on leave. I think it's a medical issue, but I never got the medical certification. I never really documented anything in the person's personnel file. And then you kind of have to clean up that mess after the fact. You have to get the medical certification, determine which leave applies. Let's start the clock ticking on that leave entitlement. So we always want to make sure we're doing that up front. Communication is also key. So anytime an employee comes to us indicating that they need a leave of absence, we always want to find out the reason and document that. That'll help us determine if it's a protected leave that applies, or maybe we'll provide leave as an option under a personal leave of absence policy, but we always want to determine what's the reason. Then when someone does go out on leave, we've done the paperwork. If we need the medical certification, we've gotten that. We still want to make sure we're checking in on that person and finding out what their status is, if they're getting close to their return date. Do they need an extension on that? Sometimes HR professionals are concerned that they shouldn't be reaching out to someone while they're on leave. And while we certainly don't want to reach out about anything work-related or any work questions, because that could turn it into compensable time, we can reach out regarding their status and when they might be returning back. So really important that we're documenting everything involved with that. I also want to go over a reminder about some time off policies. So especially employers that operate maybe outside of California and they're now dipping into California, they're surprised to learn that you are actually not required to offer any sort of vacation time, holidays, personal leave of absence policies. These are all optional. So for example, with vacation, you can choose how much vacation you want to offer, if any, who's eligible. Maybe you decide it's just your full-time regular employees. You can put those parameters around that. But really important to know that once you do offer these policies, there are strings attached. So for example, with vacation, those are treated as wages. So you have to pay any sort of accrued vacation out at the end of employment. There's no use it or lose it in California. So it's really important that you have a competent HR professional draft these types of policies for you. Holidays, same thing. You don't have to follow any sort of state or federal holidays or close for those days. You can choose to do so in your handbook as a benefit. You can choose to pay for it. So you want to be clear in your handbook on that. A personal leave, I view this as basically a catch-all if no other protected leave laws apply. But you want to give someone some time off away from work. So for example, maybe they just lost their home in a fire, or maybe they need time to relocate, they're moving, or they're going through a difficult time personally, maybe going through a divorce. You could apply a personal leave of absence policy for that, but you want to make sure you have parameters on it. So what are the types of reasons? How long are these personal leaves for? And how does someone request a leave to get approved? All right, so now we're going to jump into our leave laws applicable to all employers, but I want to start with this question of employee headcount. It is so important that you determine how many employees you have on your payroll, because as we're going to learn, there's some leave laws that kick in if you have 5 or more employees, or 15 or more, 25 or more, etc. So you want to know, okay, where do we fall? And for most of these leave laws, we are counting everyone on your payroll, all of your W-2 employees for purposes of headcount. So that includes both full and part-time, as well as on-call and temporary. So even if you have someone that's performing little work for you, if you still have them on your payroll, you haven't separated them from employment, you should still be counting them. Hourly and salaried, employees out on a leave of absence, even if they've been out for a really long, lengthy leave of absence, if you have not separated them from employment, you should be counting them to determine headcount. For employers that operate in and outside of California, this is a big question. Are we counting only our California employees, or are we counting everyone? And for almost all of our leave laws, we're going to go over one exception for you, but almost all of them, you are counting everyone, both in and out of state, for purposes of headcount. Now, it's only your employees performing work in California that are subject to California's protections and leave rights. But again, for purposes of headcount, we do need to count everyone on a national or global scale to determine our employer size. All right, so let's kick it off with leave laws that apply to everyone in California. And one of the most important ones is California paid sick leave. And in terms of eligible employees, it's really everyone, both full and part-time. As long as they've worked at least 30 days for you, they are eligible for paid sick leave. And they can use this time not only for diagnosis, care, or treatment of an existing health condition, but also preventative care. So maybe they just want to attend their annual wellness checkup. They're able to use the time for that, and also to care for covered family members for any of those reasons. Now, again, it's really important to refer to your specific employee handbook, because employers have a couple different options in how they can offer paid sick leave in California. So one of the big ones is the accrual method. Your employees might accrue paid sick leave, so they can accrue, the default would be 1 hour of paid sick leave earned for every 30 hours that they work. And if you use an accrual method, you have to allow them to continue accruing up until they hit at least 80 hours or 10 days, whichever is greater. Now, you're going to want to check your policy, because if you don't have a cap explicitly stated in there, they're going to just continue accruing indefinitely. So again, our handbook policies are so important. You can also limit how much they can use per year in your handbook policy. So you can limit it to 40 hours or 5 days, whichever is greater per year. And so while someone might have a bank of 80 hours or the equivalent about 2 weeks, they're only accessing about 1 week per year if you put that cap on it. And then they would start the new year with at least 1 week still in their bank. Sick leave was recently expanded within the past few years. It used to be 24 hours or 3 days. They bumped it up to the 40 hours. So if you haven't updated your handbook in a while, you want to make sure that you get around to that. The other primary approach is the lump sum method, or the front load method. It's a lot easier to administer. So that is where you're just granting a lump sum or front loading 40 hours or 5 days just up front. And that person might use it or might not throughout the year, but it's going to reset on the same day each year, so that everybody gets a fresh bank of 40 hours or 5 days on January 1, for example. Or maybe you use July 1. Some employers even use employees' anniversary dates, so they're all resetting at different times. So in that case, you don't have to worry about accrual and carryover, so it's a little easier to administer. Now, for either method, you can include in your policy that for any new hire, they have to wait until the 90th day of employment to use paid sick leave or to access paid sick leave. So it starts accruing from day 1, but you can put that usage restriction on it. Important to know about paid sick leave, unlike vacation, you do not have to pay it out at the termination of employment. The one exception to that is if you combine paid sick leave with vacation under one paid time off or PTO program. Once you combine it all, then all of it has to be paid out at the end of the employment. So that's one of the reasons we really recommend that you keep sick leave and vacation in separate banks, separate policies. Paid sick leave is very protected in California, so you want to make sure that you're not retaliating or counting paid sick leave use against somebody's attendance. So our general recommendation is that even if someone gives you little to no advance notice of using their paid sick leave, you typically would not want to engage in disciplinary action or count that against their attendance, just because it is so protected in California. And then the covered family members, it's a long list. So it's parent, child, spouse, registered domestic partner, grandparent, grandchild, sibling, as well as a designated person. So that's a concept that also came up in the past few years, an update in the law. And that is basically someone that they select as equivalent to a family member. It could be a roommate, could be a dear friend. If you want to limit that, you can limit it to one designated person in a 12-month period. But again, you would have to put that in your policy. Also important to know that there are some local paid sick leave ordinances out there that may require more than what the state requires. A lot of them are in larger metropolitan areas in both Northern and Southern California. So one example is Los Angeles City. They require that you provide at least 48 hours for use per year rather than 40 hours. So you want to be careful if you have employees that work away from maybe your main location or headquarters. These local ordinances are based on where the employee is physically working from, and that could include your remote employees. We have a great fact sheet on our HR forms page that is accessible to everyone on local ordinance requirements, including minimum wages. You're also welcome to call into the hotline if you need help identifying whether you fall under a local ordinance. All right, so another really important area is workers' compensation. And how this comes up in the context of a leave. Someone may become injured at work. Let's say they fall and break their arm, and now they need to be out of work for surgery. Well, in addition to all of your workers' comp process, giving the employee the claim form and starting that side of it, you also always want to be thinking about leaves of absence. And there's really no specific duration limitation. I find that it can sometimes be a misconception for employers that they think, well, if someone's been out for workers' comp for a year, after that we can end employment. And that's absolutely not true. So it is very gray. And there's also what's known as Labor Code Section 132A, which states that you should not retaliate against a worker who's injured in the course and scope of their employment. So we always say, every case is different. But if you have someone that's out on a workers' comp leave, it's a really good idea to consult legal counsel before ending their employment. Also, and I want you to highlight and star this is a really important point. Anytime someone goes out for a workers' comp issue, you always want to consider whether the California Family Rights Act or FMLA might apply if they're eligible for that. So often CFR and FMLA do apply during somebody's workers' comp leave. And I can tell you that's a common mistake that's made amongst HR professionals. They forget to designate that leave and start it. And so what happens is someone could go out on this lengthy workers' comp leave. They could come back and they could argue, well, I still have my 12 weeks of CFRA, or I still have my 12 weeks of FMLA available. And if you never designated that, they might be successful on that argument. So we're going to unpack those leaves, of course, in great detail, but I just wanted to call it to your attention here. Now, let's say CFRA, FMLA don't even apply. You should still consider providing a leaves of absence as a reasonable accommodation under the ADA or FEHA. So there's a lot to consider when it comes to workers' comp. Now, this is one of those cases where for a workers' comp leave, you can require the use of vacation for unpaid or partially paid leaves if you have a written policy on that. All right, another one that applies to everyone is voting time off. As you'll see, there's a lot of leave laws that relate to exercising one's civic duty. California finds that very important. And so for voting time off in any statewide election, an employee can get up to 2 hours without the loss of pay to go vote if they don't have sufficient time outside of working hours to vote. So as I mentioned, a lot of the leave laws that we're going to talk about in this training are unpaid. This is not one of them. So this means that you are fronting the cost of that. They're not dipping into their accrued vacation or paid sick leave. You have to pay them for those 2 hours that they're out of work to go vote. Now, they do need to give you 2 days advance notice, and it does need to be at the beginning or the end of the work shift. You can require that unless it would be less disruptive for them to go at lunchtime, for example. You could mutually agree to letting them go then, but otherwise it would have to be at the beginning or end of the work shift. Another important thing to know is that 10 days before a statewide election, the employer is supposed to post a voting time off notice for employees, informing them of this right. Now, if you have an up-to-date all-in-one labor law poster. If you might have gotten that through CEA, then that voting notice will already be on there. So it's already posted up in your workplace. But if not, be aware of that requirement. All right, so let's talk about school appearance leave when your kiddos might get into a little bit of trouble. There is protected time off for that to appear at the school for disciplinary matters related to one's child, or if their child has been suspended. There's really no duration on it. The law, the way it's written, is you just can't discriminate against someone, or they can't face adverse consequences for having to take this time off. Now, they do need to provide you reasonable notice of needing to take this leave. And this is one of those occasions where you can say, well, you need to use your vacation or PTO to cover this time. Now, this time off otherwise is unpaid unless they are using their vacation or PTO. But be careful with exempt employees. And this goes with any leaves of absence that we're talking about, or I should say most of our leaves of absence that we're talking about. Generally, the rule is that if an exempt employee is performing work within the work week, even just a few phone calls or emails, they should be paid their entire salary for that week. So you typically should not be making deductions from salary. A lot of the times, again, we can apply accrued time, but we should be paying their full salary. So be careful with that. With our non-exempt employees, it's a lot easier because they're paid by the hour that they work. All right, military or USERRA leave is a federal law, and it applies to all private employers. And what it requires is that you grant leave to employees who are in the military or the US Reserves, National Guard. And it's one of the longest durations that are spelled out for us. So it's up to 5 years of protected time off. But it can happen intermittently. You know, I haven't run across a situation yet in my career where I've had someone call and say they had someone that was out for 5 years. Usually it's in shorter increments of time, but that's on the table. Now, time off is for things like military training, drills, cruises, special exercises. And this is a pretty protected leave because following that leave, someone has the right to reinstatement to their same equivalent position, and they get full seniority as if they had never left. So as if they had been working that entire time, they get the entire seniority for that. So there is a lot with USERRA. We're not going to go into a ton of detail with it today. We do have a great toolkit on this. If you're a CEA member and you come across this leave and you need the forms and notices, we do have that available for you. All right, what are some other leaves that apply? As I mentioned, California wants people to be able to exercise their civic rights and civic duties. So jury duty is protected if someone receives a jury summons. You can require reasonable advance notice. And again, for your non-exempt employees, this would be unpaid time. But there are a lot of employers that do choose to offer maybe some paid time, you know, up to 3 days or up to 5 days. So that would be a matter of your employee handbook. You would want to check on that if your company offers some paid time off for jury duty. Very similarly, witness leave is if someone has received a subpoena or court order to testify. Again, they would have to give reasonable advance notice. And then emergency duty. So that is emergency duty leave for members of disaster response teams, such as voluntary firefighters, peace officers requested by the state. So if it's a state of emergency, they've been called to respond. Maybe a wildfire, they're dealing with those types of issues. We have to allow this time off. It is unlimited, and it's actually a crime if we do not allow this time off. If we deny it, it's actually a misdemeanor. All right, and the last one that I'm going to talk about that applies to all employers is crime victims leave. And this got a lot of attention this year. There was an expansion of it for 2025. And there are some additional requirements for employers that have 25 or more employees that Astrid's going to cover in her section. But what this is time off for crime victims to seek court relief either for themselves or their child. So a common scenario is a temporary restraining order. If someone's maybe a victim of domestic violence, for example, and they need to take time off to go to court to pursue that. We also have already been required under the law to reasonably accommodate an employee for their safety at work if they're a crime victim. So for example, they might say, you know, I'm concerned that I might, you know, be attacked at work. Can I have a lock on my door, or can I be permitted to carry my cell phone at all times so I can contact law enforcement, those types of things. Now it's been expanded just a bit that if the person's family member is the victim, that they could still request these reasonable accommodations in the workplace if they, again, have a fear of their safety. Now, for crime victims leave, employees can use their paid sick leave, vacation, PTO to turn it into a paid leave. And then lastly, even if you don't have anyone that's a crime victim in your workplace, hopefully you don't, there are new notice requirements that should be on your radar now in 2025. So when the law was expanded, the California Civil Rights Department was tasked with making a new notice for employees on their crime victims' rights, and they have to publish that notice by July 1. So we've been waiting and watching for this notice. We haven't seen this yet. We will update you if you follow our blog at employers.org once we get word of that. But once they do publish it, the requirement for employers is that you distribute this notice to all employees upon hire. So you're going to want to add it to your onboarding paperwork, to all employees annually. That one's pretty interesting because it's not like we're just posting this up in our workplace. We actually have to physically distribute it to our employees, just like we do with a W-2, for example. And then if someone makes a request for this notice, or anytime the employee informs you that they or their family member is a crime victim, then we need to provide them this notice. So put that on your calendar. Be on the lookout for that by July 1. All right, so we made it through arguably the longest section, which is the laws that apply to everyone. Now we are getting into that next threshold. So if you have 5 or more employees, what laws apply to you? And I can tell you some of the major ones now kick in, even for just very small employers with 5 or more employees. So the first one that we are going to go over is pregnancy disability leave. So again, if you have 5 or more employees on your payroll, this applies to you. But also, even if your headcount fluctuates from time to time, it may still apply to you, even if you drop down to 4 for a little bit. The standard is if you regularly employ 5 or more employees. And the regulations on that provide an example. They said if you're a seasonal employer and at the height of your season, you're at 5 or more employees, then you are actually covered by this law, even if you're not maintaining 5 or more throughout the entire year. So be careful with that. Now, to be eligible, what are the requirements? So it's anytime a healthcare provider states that the employee cannot perform one or more of the essential functions of their job without undue risk to themselves or their pregnancy's successful completion. So as you'll see, there is no length of service requirement or number of hours that someone has to work to be eligible. For PDL, they are eligible on day 1 of employment. So even if they didn't mention to you in the hiring process that they're pregnant, if they come to you on day 1 of employment, they give you that healthcare provider certification, they are entitled to this protected time off. Now, the timing of PDL really can vary from person to person. So it could be before the birth, at the time of the birth, after. There's a whole host of issues that could be considered a pregnancy-related disability. So severe morning sickness, hypertension, loss of pregnancy, postpartum depression, all of those things would fall under pregnancy disability leave. So it really just depends, again, from person to person, what they're experiencing and what their healthcare provider certifies that they need. All right, so that brings up the question then, who exactly is a healthcare provider? And if there's one takeaway from this slide, I want you to know that it is very, very broadly defined in California. So not only is it a licensed physician, surgeon, or doctor that's directly treating the employee or maybe overseeing their treatment, but it's other healthcare providers, marriage and family therapists, acupuncturists, psychologists, physician assistants, chiropractors. So basically, if you receive a certification from a healthcare office that someone is disabled by pregnancy, you can pretty much assume that that is going to be sufficient to allow this person to take the time off. It's very, very broad in California. All right, so what are some of the things that employees get with pregnancy disability leave? This is one of those leaves that comes with a lot of additional protections. So one of the big ones is job protection and a right to return to their job or a virtually identical position, or the right to reinstatement is another way to put that. And that means that they are returning to a job that is equivalent in pay, benefits, duties. They need to come back to the same position that they left. They also get continuation of group healthcare benefits as if they were currently working for you. So they are responsible for their share of the premiums, but you have to continue that group health coverage throughout their entire pregnancy disability leave. And what can happen, let's say if someone's maybe not using their PTO or vacation to cover that time, you're not able to make any of those payroll deductions for their share of the premium. So you typically want to work it out with them that they're either writing you a separate check, they could do it before they leave, or even send it in, let's say on a month-to-month basis to you, or you could work it out that they catch up on those payments when they return back from their leave. Now, additionally, they could access state disability insurance, wage replacement benefits through the EDD, but that is on them to apply for those wage replacement benefits. And then also really important to know, anytime you're informed someone is pregnant, you should be giving them your lactation accommodation policy. So this is something that is required anytime pregnancy is disclosed regarding pumping rights at work. And it's actually one of the required new hire documents that you want to make sure you have in your onboarding forms as well. All right, so how much time does someone get off with pregnancy disability leave? It is up to 4 months or 17 1/3 weeks. And it is prorated based on how many hours someone is working per week. So for a 40-hour a week employee, that's the equivalent of 693 hours of pregnancy disability leave. Now notice that I say up to. It's not automatic every time somebody is pregnant that they're going to get 4 months off. It's whatever the healthcare provider is certifying that they need. And it might be intermittent. It might be, let's say in the beginning, maybe they need some time off because they're experiencing severe morning sickness, and then they get a little better. They're able to come back to work. And then maybe towards the end again, they're dealing with an issue, and so they need to go off work. So it's whatever the healthcare provider states. Now, in a typical pregnancy without any additional complications, generally in California, someone will be considered disabled 4 weeks before their due date, and then 6 weeks after the birth of the child for a natural birth, and 8 weeks for a C-section. And again, that's just in a typical pregnancy. So you're looking at about 10 weeks or more that someone could take off. And it doesn't mean that they necessarily are going to. Some people might choose to work all the way through their due date or come back early, but it just gives them that entitlement generally. But again, all cases are different. The amount of leave is per pregnancy, not per year. So there's no cap on the number of times that someone could take PDL. As I mentioned, it can be used intermittently. Employees can turn it into a paid leave or a partially paid leave. So they can choose to use their available sick leave, their available vacation or PTO. But know that for pregnancy disability leave, you cannot require an employee to use their vacation or PTO. So this is one of those where you're not allowed to do that. The employee could choose to use it, but you cannot require it. When it comes to mandatory paid sick leave, the law is not exactly clear on whether you can require an employee to use mandatory paid sick leave. So if you offer sick leave, beyond mandatory paid sick leave, you could require use of that. But if you're offering the minimum mandatory, we recommend not requiring the employee to use that, just because the law is not exactly clear on whether that's allowed. All right, so let's talk about the fun part, the paperwork. And can you hear the sarcasm in my voice on that? So anytime someone informs you that they are pregnant, you want to provide them the pregnancy disability leave posting from the Civil Rights Department. So that's a standard form that you can find through the CRD. And then anytime we have indication that someone needs a reasonable accommodation related to their pregnancy, maybe they're not wanting to go out on leave, but they say, I need to be provided maybe a special seat or something along those lines. We want to provide that medical certification form, or if we have indication that they do need to go out on leave. And that is due within 2 business days of learning that someone might need an accommodation. We recommend that you use, again, the sample form from the Civil Rights Department because it's compliant with California's requirements. And then you're going to want to allow at least 15 calendar days for the employee to return that medical certification back to you. We also want to provide the pregnancy disability leave notice within 10 calendar days that basically just puts the person on notice of their eligibility, rights under the law, and then also the SDI brochure from the EDD. So this provides the employee information on how to apply for those wage replacement benefits through the EDD. So we're not required to initiate that process, but we do have to give them information on it. And then finally, of course, very important, is that we provide some sort of correspondence or letter for the employee and their personnel file that grants or denies the leave, indicates when it starts and how long it's expected to be for. So we again start the clock ticking on that 4-month leave entitlement. One other thing to consider here is that someone may also be eligible for FMLA at the same time as pregnancy disability leave. So PDL and FMLA run together if someone's eligible for that. So you would also want to complete all of the paperwork for FMLA and get the clock ticking on that 12-week leave entitlement. Now, CEA members, you do have our leaves of absence toolkit that has all of these forms and instructions in there for you. If that's something that you need, if you're not a CEA member, we do offer it on our store at employers.org. You can go purchase it there as well. All right, so let's jump in now to the California Family Rights Act leave. And I guess one other point I want to make here, I said, FMLA runs at the same time as PDL. CFRA does not. The California version that we're going to talk about right now never runs at the same time as pregnancy disability. So what happens is in these circumstances, oftentimes someone will go out on their pregnancy disability leave. That's up to 4 months of time off potentially. And then once they recover from their disability, they can take time off then to bond with their child under CFRA if they're eligible for CFRA. And as we'll learn, that's up to 12 weeks. So if you're doing the math, that is potentially around 7 months off of job protected leave because CFRA and PDL do not run at the same time. So just be aware of that. So let's dive deeper into the California Family Rights Act and who it applies to. So again, it's if you have 5 or more employees on your payroll. It has the same standard where if you regularly employ 5 or more, just like with PDL, you should assume CFRA applies to you. If it does, you are required to post the CFRA poster by the Civil Rights Department. And this is one of those mandatory policies. You do have to have a CFRA policy in your employee handbook. Now, just because you're a covered employer doesn't necessarily mean that you have eligible employees. So let's talk about the eligibility requirements. And you're going to see that there's a few more here than we had with pregnancy disability leave. So person needs to work at a California work site, have worked for 12 months for the employer. So we do have a year of service requirement here. And they need to have worked at least 1,250 hours in the prior 12-month period before they need to take the leave. So you look back 12 months, did they perform at least 1,250 hours of service? That can apply even to some part-time employees. That's the equivalent of working a little more than half-time. So don't assume that your part-time employees aren't eligible for that. Now, once we determine, yes, somebody's eligible, now we need to see really if their leave falls under one of the covered reasons and if we need a medical certification for that. So that would then be the next step. Now, what are the covered reasons that someone could take CFRA leave? So we already talked about baby bonding. So that is after the birth or adoption or foster care placement, someone can use CFRA leave within 1 year of that event. So within 1 year of the birth, they have that entitlement. If someone is dealing with their own serious health condition, again, you want to check that anytime someone's going out on a workers' comp issue. As I mentioned, we should always be checking for CFRA FMLA. As I already discussed, pregnancy doesn't run at the same time as CFRA, so that's separate. If the person has a family member, covered family members in the armed forces, and they've been called for a military exigency, the person can take time off to be with that family member, and then to care for a family member with a serious health condition. Now, the list of covered family members is the same long list that we went over for paid sick leave, including a designated person. And again, if you want to limit them to only one designated person in a 12-month period, you're going to want to put that in your policy. All right, so what do employees get with CFRA? So we're going to see very similar to those additional protections that we have with PDL. In this case, it's up to 12 weeks of unpaid leave in a 12-month period. Just like PDL, they get job protection and the right to return to a virtually identical position, continuation of group healthcare coverage, although they're responsible for their share of the premiums, and they can still apply for wage replacement through the state. So when they are out dealing with their own serious health condition, they would apply for state disability insurance. When they are caring for a family member or their baby bonding, they would apply for paid family leave. Now, paid family leave is only up to 8 weeks of wage replacement. Someone could still get the full 12 weeks off with CFRA, but up to 8 of those would be paid. Now, they can take it intermittently, and they can take it in very small increments. So they could take it in as little as 1 hour increments. Let's say if they need to just go to a doctor's appointment, we can't require them to burn more CFRA time than that. The one exception is for CFRA baby bonding. You can require a minimum duration of 2 weeks so that they're taking it basically in 2-week chunks, but you need to give them 2 exceptions to that where they can use it in 2 shorter time chunks. So again, leave laws can just be very, very nuanced in California. We have a little cheat sheet for you here that you can refer to. It's in your handouts if you want to look at the covered family members, eligibility requirements, etc. All right, so let's talk about the CFRA paperwork. Just as much fun as PDL. We have a lot to cover. So when we learn that someone may qualify for CFRA, and really important point here, they don't have to use any magic words. They don't have to say, I want to use my entitlement under California Family Rights Act. They might just say, hey, I'd like to take some time off to be with my new baby. That would be enough of a trigger. We need to provide the notice of eligibility, letting them know, yes, you have performed that year of service, 1250 hours, or no, you haven't. And it would cover also the rights and responsibilities under CFRA. We also, and that has to be due within 5 business days of learning that CFRA might apply. Then we also have to provide the medical certification form for them to take to their doctor and allow at least 15 calendar days for the employee to return. The one exception is for baby bonding. You do not ask for the medical certification form for baby bonding. If you want other documentary evidence that that baby was born, for example, you could ask for a copy of the birth certificate, but you don't need a medical cert for that. And then once you have sufficient information to determine, yes, they do fall under one of the covered reasons for CFRA, they provide that medical cert back to you. Then within 5 business days of that, you need to actually designate the leave with a designation notice. This is really important because, again, this is going to start the clock ticking on that 12-week leave entitlement. You want to provide them the brochures from the EDD on SDI and paid family leave. And then here again, we have to consider if FMLA also applies. If you're a 50 or more employer, CFRA and FMLA, a lot of the times they run concurrently, not always, but a lot of the time they run concurrently. And you might have a situation, for example, where someone went out on pregnancy disability leave, let's say for 4 weeks, and they used 4 weeks of FMLA. That's how much they've burned. Then they go to baby bonding with CFRA. They have 12 weeks and maybe only 8 weeks left of FMLA. So then you get through the 8 weeks, FMLA falls off, and then they have those additional 4 weeks of CFRA. So we want to make sure we're documenting all of that and we're ticking that clock on those leave entitlements. We don't want any argument, well, you designated CFRA, but you didn't designate FMLA. So I still have those 12 weeks of FMLA available. Again, we do have that leaves of absence toolkit that has all of these sample forms for you if you do need them. All right, so let's wrap things up, and then I'm going to turn it over to Astrid here in just a second. So just some things to remember. PDL and CFRA time off are unpaid, but employees could choose to use their accrued time off. We cannot require use of vacation or PTO for pregnancy disability leave. We can require it for CFRA for any unpaid leaves, but that can also be a little bit of a tricky issue. So you can always call into the hotline and get some guidance on that. You do need to continue health care coverage during both PDL and CFRA leave. And then following these leaves, the employee does have a right to reinstatement to a virtually identical position. Another important point just to remember, the Civil Rights Department did recently update some of its notices and postings for 2025. So do make sure that in your workplace you have those updated posters or an updated 2025 all-in-one labor law poster. So with that, I'll let Astrid jump back in here and see if we have any questions we can answer before we kick off the second half.
Yeah, thank you, Juliana, because that's a lot of information and you somehow do that so well. So I always learn so much from you, Juliana, and it's, like I said, a lot of information, and but you have the handouts as well, and you have the hotline to call into, so don't feel overwhelmed or too like it's a lot, because it is a lot. But Juliana, I did have a question come in, and one that is actually often called about, and that is if we forget to designate the leave. So we told them, sure, take the time. At the time, they didn't realize how much they were going to actually need, and so now they're in a position where they don't know that. Now we know they're going to be gone for a while, and they didn't designate. and it's been 4 weeks already into it. So what do we recommend? What do we do from that at that point?
Usually, I recommend designating it as soon as possible so that you do start that clock ticking if they're still out on leave. If you want to make the argument that it has started that clock ticking from the moment they went out on leave, I would consult legal counsel about that. Usually, there is an argument. If you didn't designate it, they still have that entitlement available.
Okay. All right. Yeah, that's a good question. We get that one often because that happens, right? You're
Yes.
going about your business, or you just think, I didn't know if they were eligible. We just let them go out. We were being nice, but so good information. Let's see. I think that was the only question that we had out there. And again, another one that's pretty common. So thank you for your time right now. I appreciate it. And I'll let you take over the Q&A, and please keep those questions coming. That's what we're here for today. Sometimes we do this webinar in 60 minutes, and as you can see, that would be really difficult because leaves of absence is it's a lot of information, and we don't want to overwhelm you. It's a lot of details. Like she said, it's very nuanced. So, we can go through this in a webinar and talk it out, but a lot of times until it happens to you, you're going to have to go through which leave applies. And if you're sitting here going, we're only halfway through, how can we not be done yet? I know there's a lot of leaves in California, so I'm going to take over. We're just about done. Some are refresher, but we'll get through the rest of the leaves that may apply to your employer size. And like I said, keep those, there's a Q&A. We prefer you to ask your questions on that Q&A so Juliana can answer them. So let's move on here to bereavement leave, which Juliana touched on a little bit, but we're going to go a little bit more detail about your responsibility here. And this is for employers with 5 or more employees. Just remember, the laws changed. It used to be an option to provide bereavement, but now we must provide unpaid bereavement up to 5 days upon the death of a covered family member. And we actually will list out what a family member is. Now, your policy can be the same as the state or different. It can be different. You can say that an eligible employee is that who has been with your company for at least 30 days before the leave begins. You can have that. That's the minimum. But if you say all employees are eligible, that's okay too. This is where your handbook and your policy is going to be very important. So we define what our bereavement leave is for our company. But at the very basic level in California, you have to follow this. Employees must use leave within 3 months of the date of death. Employees are not required to use this time consecutively, meaning, they may need a certain day, like right after the death, to grieve, and then they may need time off in the future for a memorial or a funeral, something that they need to attend. So it can be intermittent, but it does need to be at least the 5 days. You can request appropriate documentation. If you do that, please make sure you're consistent, that you're doing that with everyone. You're not just asking some people that you might be iffy about whether they're lying and not others. So we want to make sure that we're being consistent in how we apply that policy. And again, the best thing is make sure your policy has these points in them, that we're actually pointing these things out for eligibility. The leave, again, is unpaid, but you have to allow the employee to take vacation and sick now. So your sick policy, if you haven't amended that, the sick leave policy has to say that they can also use sick leave for bereavement. Or if you have a PTO, a paid time off combination policy of both vacation and sick, you have to allow the employees to use that. You can also have a policy, very common, that says you can have 3 days of bereavement paid, and then the other 2 days will be unpaid. Again, just define it that way. You get 5 days of bereavement leave, 3 of which are paid, 2 of which are unpaid, but your option is to use sick or vacation time for that. Please make sure you're maintaining confidentiality. It used to be where we would, oh, we're so sorry, Susie's father passed away, and we would send out a bereavement card and have everyone sign, and we're going to send flowers. And you may be a very small employer where that happens, but just remember, when this bereavement law passed, this confidentiality came with it. And so it kind of took some employers by surprise that now we have to be careful about maintaining confidentiality. You can say things like Susie's on an approved leave, but we shouldn't be talking and discussing this unless the employee says it themselves. But we're not going to disclose who passed away, the relationship to the employee, or discuss details about what happened. Okay, so covered family members, who is covered, and it would be the ones listed here: spouse, domestic partner, child, parent, parent-in-law, sibling, grandparent, grandchild, very similar to our California Family Rights Act. So just know that those are the family members. Again, you can make that more broad if you wanted to. You can say, as needed. Make sure that it's in your policy and that you're consistent. Important to note that the leave is per death. So if they happen to have multiple deaths in a year, hopefully not, that would be awful, but it happens. Just know that this is applicable for per death, not per year. Okay, let's move on to Senate Bill 848, which is a reproductive leave, bereavement leave, different than the bereavement leave. This is also for employers with 5 or more employees. You also have to provide 5 days of bereavement leave for each reproductive loss event. An eligible employer is going to be someone who's been with you for 30 days. The limitation or how long you have to provide depends on what it is that they need, but you can limit that to 20 days in a 12-month period. And what this is for, what is a reproductive loss? A reproductive loss is defined in the Senate bill as a failed adoption, failed surrogacy, miscarriage, stillbirth, or unsuccessful assisted reproduction. And same as bereavement, there's confidentiality protections. We cannot and should not be discussing these things with our staff. The interesting part about this one, which really hurts employers, is that we cannot request certifying documentation. Ouch. So that's difficult because with all these other leaves, we can ask for supporting documentation. Now, do you have to advertise for that? Not necessarily, but you need to train your supervisor's leads management that we should not be asking for documentation when it comes to reproductive loss event. Some more things to cover with this one leave is they have to use it within 3 months of the event, unless the employee is taking another protected leave. And sometimes that's what it looks like. They might be on pregnancy disability leave, they're having complications with their pregnancy, and then there's a loss. So that it's not used concurrently, it's used separate. So they're taking their PDL, that ends because the pregnancy ends, for example, and then now they can take bereavement leave after that leave finishes. So the leave days, they don't need to be consecutive as well. They might happen where they need time off to go back to the doctor to have something else done, another medical procedure that's related to the reproductive loss. And so it can be intermittent. And this is unpaid time off, but they can choose to use accrued time. Again, this is a policy that should be in your handbook, something that we have defined so employees know their rights when it comes to this. Let's move on to our slightly larger employers now, those that have 15 or more employees. So now we're getting, most of these laws, as you can see, is going to apply to everybody. But now for those of you who are 15 or more, and Juliana mentioned some of these, are organ donation. So this is one that kind of takes some, because it's only 15 or more employees, it takes some employers by surprise. If you are donating an organ, you actually have to provide paid leave. One of the very few leaves of absence that is actually paid. And this is up to 30 business days of paid leave. There is in addition 30 days of unpaid leave in that year period if needed. You can require up to 2 weeks of vacation or PTO to be taken, but just know during that 30-day additional period. But so just know that this is, very rare, probably doesn't happen very often. You can ask for substantiation, of course, for this one, but just know that it's one of the very few that's paid. If you're donating bone marrow, it's 5 business days of paid leave. So another one that's actually paid, but it's only 5 business days. You can require the use of vacation or PTO for the entire leave. And then for both leaves, again, that written notification is something that you should probably require. And then the employee can choose to use sick time to cover them as well if they're going to need a little additional time off. Civil Air Patrol is another one that is necessary or required for our employers with 16 or more. And volunteer members of the California wing of the Civil Air Patrol, if you have anybody in that area, probably unlikely, but you may, they can take up to 10 days of unpaid leave when they're called to respond to an emergency operational mission. So just know that is something that is out there. Pretty much when an employee says, I need time off, you're going to look through, there's probably something protecting this employee, and we're going to go through the list of things. Now we're getting into our slightly larger employers, to those with 25 or more employees. What are you responsible for doing? Well, we know that we're all responsible when you're 5 or more for the crime victims leave. So Juliana went through that. There's a little bit of changes to those for in the law when it comes to employers with 25 or more employees. So prior to January of this year, it was defined as crime victims being time off was required for employees who are victims of a crime to seek very specific medical attention, mental health, and victim services, and engage in safety planning. But the changes now are expanded protections. So for those employees with 25 or more employees, we have an expansion of those definitions. So now it could be for a wide variety of reasons, as you're seeing here: court relief, legal proceedings, medical attention, mental health services, safety planning, relocation to secure new residence of the school for the child, providing care for a family member recovering, providing child care or care to a dependent adult to ensure safety. So now we're adding that of a family member who may be a victim of a crime. So maybe your employee is not the victim of a crime, but maybe they have a brother who is a victim of a crime who needs assistance and help getting support or getting mental health appointments or getting providing childcare to that individual. You have to now, for those employers that have 25 or more employees, have to extend that protection to that family member. So that employee needs to be there for that family member. Employer may limit the total combined leave for all reasons to 12 weeks, and you are going to run concurrently with CFRA and FMLA when applicable. It may not apply, but if it does, if they need time off and it makes sense, you're going to run them concurrently. When the employee's family member is the victim, we don't have to allow as long a time. Hopefully they're still alive and well, but the language is written so long as they're not deceased. The employer can limit the leave to 10 days total, or 5 days when all they need help is relocating a child or relocating the persons to a different home. So there is a little bit of added language, again, for those employers with 25 or more employees when it comes to crime victims. Okay, let's talk about drug rehab for those employers. Again, if you have more than 25 employees, we have the drug and alcohol rehab. So if an employee says, even if it's in the midst of, you're disciplining them for something, and that's usually when it happens, we're addressing a concern with the employee, and then now they tell us that they need time off, they need to go to rehab, they have a problem and an issue and a concern, and it deals with drug and alcohol, and they're going to need a leave for rehabilitation. You have to allow it. This is a job protection for them. There is no duration limit. So if they say this is going to take 60 days or 30 days, then that's what it takes. There's no advance notice on here. There is an undue hardship clause, which we're going to say seek legal counsel to see if you are eligible for that undue hardship. You really have to prove that your business is really going to be impacted in a very difficult way to not allow this. You do have to allow sick time because this is an unpaid leave, so you have to allow for sick time if that's what the employee wants to use. There are some safeguard privacy, meaning that the safeguards the employee's privacy concerning their enrollment in the rehabilitation program. We're not advertising this to everyone that Susie went on rehab. And then Labor Code 1025 aims to support that employee seeking treatment, meaning you need to be supportive. We're offering a reasonable accommodation to participate in this program, and we're offering a stigma-free workplace where there's no judgment here, and ensuring that the employee is seeking treatment for substance abuse, and ensuring we're not discriminating against them for needing this. Okay, we have schools activities leave. This is a little bit nicer, happier reason for an employee to take a leave. Again, this is for 25 employees or more at the same location. So this one's a little different, where most leaves, if you have 25 employees anywhere, this applies. This, for the school activities, they do have to be at the same location. And this allows employees to participate in activities of the school or the licensed child daycare of a child. So this is for things like field trips, plays, school meetings, conferences with teachers, things like that. And you do need to allow them to take up to 40 hours in a year. This is, again, unpaid. You can require for them to take vacation, and I would. You want to make sure that you write in your policy that this is an unpaid leave. However, if they do take it for school activities, we will require you to use any accrued vacation time they have available. You can limit that to 8 hours in a month, and it's 40 in the year. Unless it's an emergency, like I need to go, there's a conference which is called into, then you have to allow it. You can require documentation of attendance if you feel like there's abuse in this leave. Typically not, but if and it's not too much time, but you can require that if you'd like, a school program, possibly something from the school saying that they participated in a field trip, perhaps. And you can limit this if both parents are employed. So just know that if you have somebody working for you and the two parents are there, you can limit that use. All right, we have military spousal leave. So we know military families face unique challenges. So this leave is for them. So this is an eligible employee will be someone who works for you an average of 20 hours per week. And this allows up to 10 days of unpaid leave. If, let's say, a soldier is deployed overseas and they are allowed the military grants them perhaps a 10-day leave of absence to return home. This will allow the spouse to take time off and spend with them. So you can allow vacation, but with this one, we can't require it. So if the employee says, oh my gosh, my spouse is coming home, I really want to take time off, but I already have that planned vacation in December. I don't want to take my vacation. I want to take this as unpaid. You have to allow that. Okay, so we can't force them to burn it in this case. We do want them to give us 2 business days notice. Typically that is something they know is coming, not much notice, but something that they can if they're able to. And again, that service member must be on leave from deployment in order to qualify for that leave. Okay, now we're into our big employers. And before you small employers tune me out, just know that you can easily maybe get to 50 employees, or you may have 50 employees where you get to if you have them anywhere in the world. So these leave laws may apply to you. There's actually not very many that apply to big employers. As you can see, almost all these will apply to everybody. And this is for our largest employers. So just a little bit of time here. I'm going to actually give you a poll, and this is going to be for everyone. But I want to just, let's see if I can get my poll here. I'm going to ask the first question to you all, just to shake things up a little bit and wake you up. So in March, your employee who has worked full-time for your company for 3 years, they've been with you for 3 years full-time, and works at your corporate office, they have 75 employees on site, they tell you that they need to take a leave for 3 months. They need 3 months off to care for their grandma who is sick. So what leave is your employee entitled to take care for her? So this employee has been with you for 3 years, and is a full-time employee, needs time off 3 months to take care of his grandma. What leave will apply here? Let me know on that. I'll give it a little bit of time. This is for all employers can participate. Okay, I'll give it just a little bit more time. More than half of you have answered. Okay, I'm going to stop and end the poll there. And I'll share the results. Okay, so somebody said CFRA only. The majority of you said CFRA and FMLA. You're going to designate both. Nobody said reasonable accommodation. So you got the fact that the employee has been with you for a full year, for more than a year, which is good. They are in a site that has 75 more employees, which was kind of a trick question here. But they are actually only eligible for CFRA because grandma is only covered under CFRA, not under FMLA. So grandma is a covered employee under CFRA only. So make sure that we designate the correct leave. So we're only going to be designating CFRA in this case. Let me launch the next poll here. Let me go back. Okay, let me launch number 2. So in July, the same employee breaks his leg while skiing at Lake Tahoe. He now needs to take 2 months off for surgery and recovery. Is this employee that took leave for grandma eligible to take a leave for his own serious health condition? So we remember, I kind of gave you a hint here. We were only able to designate the CFRA because that was for grandma. So does he still eligible to take more time off now that he broke his leg? And so I think you guys are all getting it here. I'm going to end the poll, share the results. So yes, the majority said yes, nobody said no, which is good. And some people said, well, maybe. And yes, because we know he's an eligible employee, he has been with you a long time, full time, he meets the eligibility, which we're going to talk about next under FMLA. Yes, he would be eligible. So think about that for this employee here. we're having approximately 24 weeks of unpaid job protected time off. So we're having that 3 months for his grandma under CFRA, and then now he needs an additional 2 months, possibly more, under FMLA. So that's a lot of leave time, and that's why it's important to designate the correct leaves and that we're actually designating them, right? So let's talk a little bit about FMLA and why this is a wild beast, right? So for those employers who have a lot of employees, this may apply where you're designating multiple leaves where we can't do them concurrently. So for the FMLA, you have to have 50 or more employees on the payroll in the 20 or more work weeks in the current year, or you have to look back at the preceding year to see if you meet that eligibility. So if you're right at the cusp, you're really going to have to look back and see if you met that 50 at any point. You have to post that FMLA poster and have an FMLA policy. And then covered employers do not necessarily have eligible employees, as we'll learn soon in the next slide. We'll learn about who is an eligible employee. So just having the 50 doesn't mean they're eligible. And then similar paperwork requirements, those lovely paperworks under CFRA is going to be very similar to what we need to require an employee to do for FMLA. Be careful for those of you who have temp employees and you're in a joint employer situation, because those temp employees who work for you at least 1 year must be counted as employees on your payroll to determine whether you're a covered employer. So when you're looking at head count, you're going to have to count those temp employees. So be careful with that as well. So with FMLA, the eligibility, you do have to provide, very similar to CFRA, that 12 weeks of unpaid leave with benefits. If they worked for you for 12 months, worked 1,250 hours, that's the magic number in the prior 12 months, and work at a location with 50 or more employees in a 75-mile radius, which is what our friend did in that example. So if this is the people who will be eligible, a lot of times employers will call in and say, I have to designate FMLA, and really they don't, because maybe the employee doesn't meet this eligibility. So make sure we're very specific about asking these questions and researching them before answering that employee. So what do they get with FMLA? Similar to CFRA, they're going to get 12 weeks of unpaid time off in that 12-month period. The only difference would be for military caregivers. So if a military caregiver is caring for a service member who's seriously injured or harmed, they are allowed up to 26 weeks if needed. And that employee has to be, very specific as to who they're caring for. It could even be the next of kin. So military is slightly different in their FMLA protections. But for typically everyone else, there's, again, job protection and right to return to their job or a virtually identical position. And that might come into play when you have somebody out that long, either 12 weeks or 26 weeks for military. You probably hire someone else to do that job. And I can't tell you how many times magically they find a better employee. Somehow that always happens. There's a better employee doing the job and we don't want that other employee back anymore. Well, that's why this law exists. You have to return them to the same or virtually identical position. It really protects that employee who you probably don't want back, but they have a right to be reinstated. Continuation of group health benefits. So as if they were currently working. So whatever fee or whatever charge that you give them for their benefits, whatever they're paying for their group benefit plan, has to continue in the same way. Now, once it runs out, this is why it's important for you to put this on your handbook for both CFRA and FMLA. We want to make sure that we're saying that we're only going to cover your group health benefits while you're covered under FMLA CFRA. If this is a very long-term leave and they don't return, you may have the right to then say you need to pay for full benefits, or this turns into a COBRA situation. But if you didn't list that and you didn't communicate that to the employee, it might be a little bit more difficult situation to be in. So make sure that we're keeping in touch with our employees while they're out on leave, that we're asking them for their premium. So if they're out for 12 weeks, for example, and they pay $20, every pay period, and they're out and they're on an unpaid status, that we're requesting that group benefit, that premium from that employee, that we're telling them where to send it in, when to send it in by, and who to send it to. If they're falling behind, we're sending them notice, hey, you're behind, I need $40 now this month, whatever the case may be. If they're using sick vacation time to cover, we're taking it from them. A lot of times they are on an unpaid status because they're getting paid, as you can see here, SDI or PFL, the paid either state disability insurance if it's for their own serious health condition, or paid family leave if it's for their family member. And they're getting that money from the state. That's nothing you have to worry about other than when you get that notice. Well, two things. You got to provide the notice to the employee. And then when they go apply, the state will probably send you something for you to verify. Remember, FMLA can be taken intermittently if necessary. It's not always consecutive. A lot of times it could be where I have a serious health condition that flares up, acts up, or I'm going to need treatment and I go every Friday or every Wednesday. Somehow magically happens where it's Friday. But if they have the medical substantiation, we have to allow it, and it's an eligible reason. So some covered reasons under FMLA, why would we allow it? It's for the birth of the child. So different than CFRA. CFRA is birth of a child, adoption or foster care, but we're doing baby bonding under FMLA. But they may not have baby bonding available under FMLA because you will have run the FMLA during the PDL. So I know that's confusing, but remember the pregnancy disability leave runs concurrently with the FMLA. So once they're done with that, and they no longer have FMLA, it's exhausted, then the baby bonding would come in California under the CFRA, not under the FMLA typically. So just again, confused about all that, that's what you have the hotline for. Give us a call, and we can kind of review this on a case-by-case basis. It can also be used for employees' own serious health condition, which again, that includes the pregnancy, so you're designating it then. Includes workers' comp, the way Juliana very well explained that so well. And that's so important. We forget that so much to designate under workers' comp. And then care for a family member with a serious health condition is another reason. So it may not be their own, but that of a family member. And the definition of the family member is different under FMLA than it is under CFRA. So what you have to do here is look, because there's slightly different definitions for things, you're going to look at them side by side and apply the law that is the most protective to the employee. Most cases, it's going to be the CFRA or the CFRA leave, okay? And then don't forget that we also give military caregiving under FMLA. So again, great cheat sheet. We offer you one for CFRA, we're offering you one for FMLA. If you missed everything we said, just take a look at the cheat sheet, and this will kind of tell you there all the who, what, when, where, why of the leave. So very important slide there for you to take a look at, and also to pass down to your leads and supervisors and managers. I was at a job location site at a member location yesterday, and we were going through some of these leaves, and the general manager was getting overwhelmed and called his lead over and said, do you know about all these? And lead said no. But the point was, okay, but if they ask you for this time, what would you do? And the lead said, I would say go to HR, or I would say, oh, you need 4 weeks off to care for your grandma. I have no idea if that's protected, but let's go talk to HR. And you want your leads to at least do that. Your supervisors, your management that may not be completely well versed the way HR is, but at least asking questions of, we're in California, more than likely there's some sort of protection. And so we escalate that and then we review, okay? So some final considerations here, because this is another big one, is reasonable accommodation. So we're back to all employers. So if you tune me out for the 50 or more, tune me back in, because this is going to apply to everyone. Well, if you have 5 or more employees. So if they didn't qualify for anything, they've been with you 2 weeks, or they've exhausted, they've been on FMLA past 12 weeks or CFRA past 12 weeks, they're more than likely you're going to have to consider reasonable accommodation. So reasonable accommodation lives under the California Fair Employment and Housing Act, FEHA. And this requires employers with 5 or more employees to provide a reasonable accommodation, which could include a continuation of a leave of absence for individuals with a physical or mental disability to perform the essential functions of their job. So that's what it looks like. It looks like I've been under FMLA CFRA concurrently for 12 weeks, and now I need an additional 3 weeks off. Can you provide that to me, employer? You have to look at it from the lens of the California Fair Employment Housing Act and say, is this something that would help the employee perform the essential functions of their job if they could come back after 3 weeks? And so you have to start what's called the interactive process to determine if this reasonable accommodation is available, is going to be helpful. And the law really says you really need to try. And the interactive process should be documented. And we'll go through a little bit more detail in the next slide, what that looks like. But you do need to consider it and really make an effort to go through what it is. You exhausted all possibilities. It may be where You know, an employee says, I need to take a break every 15 minutes because I have this medical condition and here's my medical note and I need to take a break. And so you say, well, I can't allow that, but how about this? And this is the interactive process. Well, how about we allow not instead of a 15-minute break, maybe a 5-minute break? Would that be okay? And the employee goes back to the doctor and says, yeah, that's okay. 5 minutes is better than nothing. And so that would help your condition. So that's what the interactive process is. The whole point is for dialogue to happen. So always consider it's either going to be under the Americans with Disabilities Act or this FEHA if no other protected leave apply, or if it has been, the leave has been exhausted already. And again, the exception would be if this causes an undue hardship. So a lot of times an employer will call in and say they want an additional 3 weeks off, and I just can't have them off anymore. I've had them off for 12 weeks. I cannot allow an extra 3 weeks. And a third party looking in would say, well, you've been without them for 12 weeks. What's another 3? If you have a temp employee there, what's another 3 weeks going to do? Is that really an undue hardship for you? We will always say consult with counsel, because there are some very narrow circumstances where it may create an undue hardship for you, but we want those to be discussed with an attorney where it's privileged and confidential, and you can really articulate the reasons why you're not able to accommodate that request. So here's the interactive process and what it requires. It requires an individualized assessment of the job requirements. So this is where those job descriptions are going to be very important, and we want you to have those job descriptions available for all your positions so that when an employee says, I can't do X, Y, and Z, you can have that job description and say it's required. And how about, what if we change a few things about your job? Would you be able to do them then? So review those specific limitations of the individuals that are related to the need for accommodation. Clear communication with the employee. We're going to be very clear. The state actually has a form, the Department of Fair Employment, well, now it's the Civil Rights Department. That's where FEHA lives, is in the Civil Rights Department. They have a free form that you can download. If you call us to the hotline, that's the one we give you as well. And that form can be accessed through our website as well. That is the one we recommend for you to use. It really forces you to ask some questions and go through the interactive process. It allows you a spot and a location for you to write all these things down. So you're going to talk and dialogue with the employee to choose the effective options of what's available. You're going to keep the door open. Let's keep talking about this. And you're going to document, document, document. Unless employees requesting leave, usually viewed as a last resort accommodation. So we're really looking at this as, this is the last step here. There is another federal agency called JAN, the Job Accommodation Network. It's a free confidential service provided by the U.S. Department of Labor. And they are experts on guiding employers through how you can accommodate. Their goal is to accommodate employees when they have a request for a reasonable accommodation. It's a free service. Know that you can always call them, reach out to them. Their website, I had it written down, is askjan.org. So ask, like you're asking them, JAN, J-A-N, which stands for Job Accommodation Network. And that's .org. So askjan.org. It's a website. You can start the process to contact them there. And we are actually going to be partnering with JAN this fall for a free webinar to assist employers with kind of those real world solutions. Because a lot of times, I know Juliana and I get a lot of those calls when we're manning the hotline on, I can't continue this. This is ridiculous. This is taking us too far into the year. And I had, intended for this employee to work on this project, and so I can't continue to accommodate. And so these are the kinds of things that will be addressed in that webinar when we partner with JAN. We'll have a representative from JAN. So stay tuned with us, follow our blog, subscribe to our newsletter so that you can keep in touch. It'll be a free webinar for employers to attend. We want to make sure we're avoiding discrimination for all of these leaves, right? I know that we're not purposely discriminating anyone, but discrimination looks like, I hired them for this project, it was going to last 6 months, and now they need to go on leave, and I don't need them anymore. Well, that's going to be looked upon as discrimination if you terminate them because they have a medical condition. Or maybe they're injured and they can only, now they need to sit for the majority of the day, but this job requires standing, and the job requires it. Well, we need to review some of those things. You may be in a position where you can say the job requires it, this is an essential function of your job, and I cannot accommodate. Or maybe slight accommodations or a different one would help. This is what the law wants you to do to avoid any kind of discrimination. So remember, we cannot take adverse action, terminate, suspend, put someone on leave of absence even, if they are asking you for a reasonable accommodation. Now, if the leave of absence is the reasonable accommodation they're asking for, that's different. But if you say, I don't have anything for you, I'm gonna put you on leave, that may be okay. We're gonna tell you to consult with counsel, but we want you to at least attempt and have that interactive process before you get to that point. So proceed with caution. If employee who needs leave accommodation is also having performance issues, that creates risk for your employer. So you want to consult with counsel when those things come into play. Retaliation claims, discrimination claims are just very high. So we want to make sure that you're aware of that. We have time for Q&A or maybe even some situations, Juliana, that you and I can talk about. But we want to just kind of final takeaways here. Review the leave provisions to ensure your employees receive the leaves they are eligible to receive. Remember, you're obligated to provide them. Like Juliana said earlier, there is no magic word. They're not going to know what CFRA is, or hey, did you run my CFRA concurrently with PDL or FMLA? Or they're not going to know those words. That's up to us as the employer to understand and know. And you're educating yourself today, which is great. But what our obligation is to notify them. We're going to tell them this is what your rights are based on what you've told me. This is what you have to do. So PDL, CFRA, FMLA, alphabet soup here. FEHA, ADA should all be reviewed as options. Remember, when an employee says, I need time off, we're going to look at all these options and see if they're eligible for them. Remember that automatically terminating an employee at the end of the leave is likely a violation of the ADA and the Fair Employment Housing Act. Don't do it. We need to at least go through that interactive process. We can't just say, oh, you're out of time, we're terminating you. So make sure we're updating our policies and that your handbook and your policies do not say that. Sometimes we see that language in handbooks where it says, if you do not return from an FMLA or CFRA, you are automatically terminated. That is not something that would be compliant. So we want to make sure you check your handbooks for that. So I know we had some questions. I don't know if there's anything worth discussing, Juliana, since we have a little bit of time.
Yeah, so first, there are some people that are asking for copies of the slides. So Stephanie did put the PDF in the chat. So make sure, just scroll up a little bit in the chat box and you should be able to find it. Otherwise, you can let us know, give us your email and we'll get that sent to you. Most of the questions that are coming in are just still clarification regarding when those leaves run concurrently or not, which is such a tricky issue. It's a really good idea to call the hotline if you do have this come up, but we can kind of maybe recap that a little bit again, Astrid. So PDL and FMLA can run at the same time, and CFRA and FMLA can run at the same time. But it doesn't always happen that way. So one of the things you mentioned on your poll, Astrid, was if it's a CFRA covered family member only that's not covered by FMLA, like somebody's grandparent or sibling, then only CFRA would apply. And so they're not running at the same time, and then they still have that FMLA entitlement. But I think where it gets the most complicated is when someone goes out on pregnancy disability leave, and if you're a large employer, because you're having to consider PDL, FMLA, and CFRA, and they might not exhaust all of that time. So then FMLA and CFRA are kind of running at the same time. So it is tricky. It is tricky, especially if you're just kind of new to this. So I would just highly recommend calling into the hotline so we can help spell that out for you.
Juliana, we used to have a chart. I don't know if we still do under our HR forms, and you all can look for it too. We used to have a chart that displayed it pretty nice, where it would say the PDL and the FMLA running concurrently, and then it would have another area for once the PDL was done, the CFRA would take over, and sometimes the CFRA and the FMLA would overlap. Do you know if we still have that one available?
We do. That's our comparison chart. So yeah, if you're a CA member, we definitely have that available, and we can send it to you if you have any trouble finding it. That's a really great point, Astrid. That helps just to see it in front of you.
Visual.
Sometimes. Yeah, I'm a visual learner too.
Yeah, me too. I went through this with the member. We kept going back and she just couldn't, and I'd send her that and she was like, thank you. That explains it. So yeah, visual learners.
Yeah, but I think otherwise, do you have anything else, Astrid, you want to share? I think we've otherwise addressed.
Yeah, I think so. No, I think that was all of it. I think the most important thing is to designate those leaves, because we do get into that trouble of having that still available to employees when we don't designate.
And it
leaves.
looks like we did have one question just come in. So they said, does the state of California pay for CFRA? So kind of, sort of. The employee could apply for wage replacement benefits through the EDD. So when they're out on their own serious health condition, they could apply for state disability insurance. When they're caring for a covered family member, baby bonding, then they would apply for the paid family leave program. But it's not a paid leave by default. I hope that makes sense. We have a lot of acronyms.
I know. And
Leaves, unfortunately.
I think that's a good point. We don't really mention paid family leave on this leave webinar because it's not a leave. So paid family leave is a wage replacement through the state, and employees get very confused because they think that's the leave. So when an employee is eligible for paid family leave, which is just the wage replacement, they're being covered under job protection, likely under the CFRA, under the California Family Rights Act.
Right.
So, yeah, lots of acronyms. All right, well, we're going to close this out. Thank you for everybody's participation. We're ending a little bit early if there's not any more questions. But, you know, we know these are some challenging times, especially in Southern California and the LA area. Hopefully you're all safe. And if you have any questions or concerns, I know I had a member, it's worth mentioning, that called in and said they were being very much impacted by employees not wanting to come in. They're in the downtown LA area. And do they need to provide leave for that? Do they need to allow that time? And remember, we do have that emergency, Juliana, remind me what it's called exactly?
Oh, it's evading me right now too. But yes,
okay.
So when there is a state of emergency, and that could be either criminal related, or it could be a natural disaster, employees have a right to not show up to the work site if they believe it's unsafe, or to leave the work site if it's unsafe, if they believe it's unsafe, it's a reasonable belief. So while it's not a leave entitlement, you can't take adverse action against someone. That's a really great point, Astrid, as that's coming up.
Yeah, that came on the hotline yesterday. So, so yeah, I know this is really real going on. So call in to the hotline, and we're going to support each other through these times. And Jason, I don't know if there's any other words that you had, but remember that you have that hotline where you can access, you also can access our website at employers.org. There's a lot of free resources there available, but always call in. We love hearing from you and talking about your unique situations so that we can assist you with all that. If you need additional extra support, of course, we also offer membership. And at a monthly basis or an annual basis that it can be paid, but we offer a lot of support if the hotline is not enough and you need a little bit more. As Juliana mentioned at the beginning of this webinar, we have programs like the HR Assist program, which would allow us to come on site and assist you a little bit more closely, either on site or through webinar. We offer different plans for just a little more help with your HR needs. And I'm going to throw it back to you, I think, Stephanie. Thanks so much for attending, everyone.
Thank you so much, everybody, for attending. Thank you, Astrid and Juliana. That was a lot of information. So please make sure you wrote down the hotline number. Give us a call if you need help with anything. Download the handouts that are in the chat box. I just put it back in, so you shouldn't have to scroll up too far. And then please click the QR code on your screen. Take a little snapshot of it with your phone. This is the survey that Jason and I mentioned at the very beginning. It won't take you more than 90 seconds. It's very quick, very fast. It lets us know how we're doing, how we can improve, what kind of topics you want to see in the future. And we really love hearing your feedback. It helps us make this a much better service for you. So please do that. If anyone is looking for continuing education credits, we have HRCI and SHRM codes, and these are typically for HR professionals looking to get some certifications. Your HRCI number is 708120. And your SHRM number is 25-XUMTS. So you can go ahead and take those down and submit those for your credits. And I believe that is it for the day. So thank you again so much for joining us. We hope you were able to take away some valuable information there. And we hope to talk to you soon on the hotline. Have a great rest of your day, everybody.